Hi, I'm Kyung-Hoon Chun from Seoul National University, the chair of this session. So in this session, we have a great paper with an intriguing title, The Tale of Two Jurisdictions, Red Chip Companies Going Private. So guess what are these two jurisdictions? With that curiosity in mind, let's welcome with big hands the two presenters from the Singapore Management University, Zhang Wei and Xu Yan.
Thank you. So I'll do a quick introduction about the paper, then my co-author Xu Yan will present the main part of this project. So this came from a course, one of the courses I taught at Tsinghua for a couple of years. So in that course, I talked about the Chinese companies going private in US. So in that course, I used initially two cases. I looked at two cases. One is a privatization of the Chinese companies incorporated in Cayman, which is very well known and very big. The other one is in Delaware. Almost nobody knows it. Very small, very low profile. I got to know it because I read Delaware court decisions. This is how I got to know it. And I look at the process of they are doing their privatization deals. I also looked at, most strikingly, the premium they paid to the minority shareholders. It was stunning to see actually the very big, very well-known Cayman company paid very little to the minority shareholders, whereas the very low-profile Delaware company paid significantly higher, at least on par with other Delaware companies in U.S. to the minority shareholders. So that struck me quite a lot, and I used that case in my initial the course to show my students. My guess at that time was there might be something here about the law, the Delaware law and the Cayman law. So maybe we know that in Delaware, the laws regulating the privatization deals, to my knowledge, probably is one of the most strict. Whereas in Cayman, I cannot say I know a lot about Cayman law. I must know very little about Cayman law, but one thing I do know, I think, is in Cayman, what is missing is the fiduciary duties in M&A deal in general by the board to the shareholders. I'm very pleased to hear that in Korea, the law has changed. Now the board owe directly fiduciary duties to the shareholders. For many years, I'm very, frustrated by the Chinese law still. It says, the directors only owe fiduciary duties to the company, not to the shareholders. I think everything probably else is fine, but when it comes to M&A deal, that's a big problem. When a company was acquired, the company will not be affected. Who will be affected? It is the shareholders. So that is the time when you need the board to owe fiduciary duties directly to the shareholders. I don't know whether my logic, is solid. But I think that probably explains, in many jurisdictions outside U.S., very little, if any, litigation against, the boards for breach of fiduciary duties in M&A cases. Of course, the going private is an extreme type of, M&A deal. So no wonder we see nothing, in Cayman, or close to nothing in Cayman that, when the shareholders sue the management, the board, for breaching of fiduciary duties. So that's a very, I think, pronounced difference between these two jurisdictions. How can I turn the pages? Okay. So I forgot what I want to say next. So then I met, my co-author Yan. I told her this idea, and she said it's interesting idea. Maybe we should do more research and to do it more methodologically. I have to admit we don't have a lot of cases, so we cannot do a quantitative study. So we just pick some cases. It's a case study. So we Yan will tell you how we pick these cases. We try to mimic, to some extent, a quantitative approach. We try to pick up the companies, as close as possible, in each pair. We basically have 4 pairs of companies. One incorporated in Delaware, the other is incorporated in Cayman, right? But I want to give you a little bit, background why there are these 2 types of red chips. Red chip means the Chinese companies listed in U.S. They both are listed in U.S. The reason is this. So there are 2 types of, listing in U.S. The front door, which is IPO. So the front door company, the Chinese companies went through the front door, almost 100%, incorporated in Cayman. It's an offshore setting. Then, of course, according to U.S. rule, they are, foreign private issuers. Whereas in another type of Chinese companies, they didn't go through the front door. They went through the back door listing. So when they went through the backdoor listing, you need to acquire a shell. And the shell was a Delaware company. So that is why those companies becomes, Delaware companies. But the consequence is, they are subject to now different set of rules, including the rules regulating privatization deals. So this is kind of the background. And another reason as I said initially, the idea was there for many years. But the reason why this year I wanted to do it, and I think it probably becomes even more interesting, is because the change in the Delaware law, the SB 21. Otherwise, the rule may not impact the privatization. If you look at the change, actually, it doesn't change that significantly about controller-sponsored privatization deals. The famous MFW rule, more or less inherited in SB 21. But the problem is how they define controllers. That changed significantly. So in the 4 pair of cases, the 4 pair, we have 4, of course, Delaware companies. Under the pre-SB 21 rule, they are all controller-sponsored privatization deals. But after SB 21, 3 of these 4 will no longer be treated as controller-sponsored privatization deals. So in other words, these deals will no longer be subject to the strict MFW rule. So the implication, if what we found here is valid, the implication is, I think it echoes what Kenneth found quantitatively. So I still think, through our case study, the corporate governance matters, especially in this kind of, I would call it extreme, M&A cases. So I think that's the sort of the introduction from me about the general background and why we had this kind of idea. Now I will pass it to my co-author, Xu Yan. She will tell you more about how we did the study and what we found.
Okay, thank you, Prof. Zhang. I will continue with the research design. To examine the effect of legal regime on deal outcomes, we construct a match sample of privatizations involving red chip companies. We start with the SEC EDGAR system. Between 2010 and 2025, we identified 30 Delaware incorporated Chinese companies listed on the NYSE or NASDAQ. Within this sample, we further find 4 completed controller-led privatizations. We then match each of these 4 Delaware cases with a Cayman case involving a Chinese firm. The matching is based on 2 factors, industry and the year of privatization. So this practice gives us 4 match pairs. The idea behind this matching design is straightforward. Because firms in similar industries and privatized in similar years are likely to face similar industry and market conditions. So matching along these dimensions help us reduce the influence of industry and time-specific factors. We Using this sample, we examine pre-transaction firm-level characteristics, including size, profitability, and the level of valuation. As Panel B shows, Delaware firms and Cayman firms are broadly comparable along these dimensions. So this matching design allows us to isolate the effect of legal regime while holding other firm-level characteristics relatively constant. We then compare takeover premiums. The final offer premium is the premium in the final merger agreement. Here, you can see the main finding is very clear. Takeover premiums are systematically higher for Delaware firms. On average, the final offer premium for Delaware firm is about 20 percentage points higher than that for Cayman firm. And also, this pattern is very consistent. Every Delaware firm in our sample has a higher final offer premium than every Cayman firm. We then look beyond the price and examine the deal process and structure. We review transaction documents to see whether procedural protections differ for those two groups of companies. Here again, the differences are quite clear. All Delaware firms in our sample required MOM voting and conducted pre-signing market checks. By contrast, none of the Cayman firm imposed MOM voting requirements and only one conducted a pre-signing market check. These procedures matter because they enhance minority shareholder protections. MOM voting shifts the decision-making power to minority shareholders. Pre-signing market checks also matter because they help the special committee obtain better information about the market and increase the possibility of competing bids. So taken together, our evidence on both price and process points in the same direction. Minority shareholders in Delaware firms tend to receive better deal outcomes than those in Cayman firms. Now let me turn to some possible mechanisms that help explain the differences we observe. The first one is about the first one is about the U.S. connection of special committee members. In our sample, U.S. citizen or resident special committee members appear in 3 Delaware cases, but in only 1 Cayman firm. Compared with their foreign counterparts, U.S. special committee members are more familiar with U.S. legal norms and the litigation culture. So because of that, they may be more sensitive to the legal risk surrounding the transaction and therefore have stronger incentives to perform their role more carefully. So the presence of these members may help special committee function more effectively, which could lead to better outcomes for minority shareholders. The second mechanism is about preliminary injunctions. A preliminary injunction is a pre-closing remedy. In the context of privatization, the most common type is disclosure-based injunction. It can delay shareholder vote until corrective disclosures are made. So for controllers, delay itself can be costly because it imposes the deal to changing market conditions. So the threat of delay may encourage controllers to offer higher premiums upfront to avoid the delay of the deal. For Delaware firms, shareholders may seek injunctions under both Delaware law and federal securities law. But for Cayman firms, as minority shareholders generally cannot bring direct fiduciary duty litigation claims under Cayman corporate law. The injunctions usually depend only on disclosure claims at U.S. federal courts, so the grounds for injunctions are narrower. So overall, preliminary injunctions are likely to have a weaker deterrent effect in Cayman firms than in Delaware firms. The third mechanism is slightly different. Unlike the first two, which are linked to law, this one may qualify the effect of law. So we make our best effort to match firms across the two different groups. One noticeable difference remains. The buyer groups in Cayman firms have larger shareholding before the transaction. Prime literature shows that larger toeholds are often associated with lower takeover premiums. So one alternative explanation for our finding is that the lower premium in Cayman firms reflect stronger pre-existing control rather than weak legal protection. However, we should be cautious about that explanation because existing literature focuses on third-party bids that choose the level of toehold and takeover premium simultaneously at the time of bidding. But our setting is different. We focus on controller-led buyouts. In our sample, the buyers already have effect control before the proposal, and none of those buyers meaningfully increase their shareholding before the transaction. So difference in ownership may matter, but they are unlikely to fully explain our results. Okay, in the interest of time, I'll stop here. Thank you.
Very quickly, so why we looked at the mechanisms? Of course, mechanism is important. You just report there's how it happens, right? It's interesting, and that's exactly because maybe Jesse Fried and his co-author has this a series of papers talking about actually the Chinese companies, it's just irrelevant. So whatever law govern it, they're irrelevant. So we want to sort of respond to their sort of papers, right, which says actually the law doesn't matter if you are overseas companies like China. So the U.S. law, no matter whether Delaware law applies or not, it doesn't matter. So thank you with that.
Thank you again. Glad to be here at ACLF. Thanks for the invitation. So I just had a couple of broad comments on the paper. The first is to kind of highlight the contributions of the paper and the background to the paper. I wish I could stop at that, but I think I have not been invited here just to praise the paper. So I may have to also add a few things, but I think it's all constructive in nature. So I just wanted to link it up with one discussion that's been, and that's where this paper I think plays an important role in the ACLF, because one question I think Kenneth asked in the morning is, does corporate governance matter? And I think this paper, when I first read the paper, it seemed intuitive that your results are quite intuitive, but it seems like it's not a done and dusted issue because people are still asking, does corporate governance matter? And the paper is trying to answer that question and therefore does still continue to make an important contribution. I think, therefore, there's a question about whether, what is the effect of legal protection on minority shareholders, and the emphasis on this paper seems to be, yes, law does matter. And what is the setting in which the law matters? I think the paper looks at the extreme scenario, which is what I would think of as an endgame scenario, which is when does the company become private? And why is that scenario important? That scenario is important because that's where the agency conflicts become the most acute, because the controlling shareholders buying over the minority shareholders, and they come from opposite ends of the spectrum. And the comparison between Delaware and Cayman Islands is an interesting one because both of them attract companies from China, and couple of other contributions. Certainly, there's a lot to say about SB 21 indirectly that this paper adds to. And I just wanted to congratulate Wei and Jan for the meticulous way in which they've conducted the research and outlined. So I couldn't find any, the paper flowed quite well. The choices of why they approach the question and how they conduct the methodology are very, very clear in the paper. And therefore, I think it does make a useful contribution at the intersection between corporate governance and going private. So just about 5 points on how to make the paper further rock solid. The first question is one of taxonomy. What does it mean to go private? It can mean two things. One, it can mean delisting from the stock exchange, or the second is it can be squeezing out the minority shareholders. And I think a lot of American literature tends to conflate the two, but I think it might be useful to clarify. I think what you really mean is squeeze outs. So it might be better to clarify this right at the outset, so that because from a Singapore or Asian point of view, going private might also mean delisting, which is different from a squeeze out approach. So I think that's kind of the first point of taxonomy. The second point is you focus on Chinese companies. And I'm quite curious to hear what is unique about Chinese companies listing in Cayman Islands or the United States. How is that different from other companies from other jurisdictions listing? So the paper can benefit by fleshing out any specific issues that matter in the Chinese ownership context as opposed to other jurisdictions. For example, would the finding of your paper apply to a company from another Asian jurisdiction that's incorporated in Cayman or the United States? I think that's kind of useful to think about. The third question is why Cayman and the United States? Why not the BVI? Obviously, I think the Chinese companies are listing more in Cayman Islands than the BVI or other jurisdictions. So is there anything else that your paper can tell us about other offshore jurisdictions? Because that would be interesting to see as well. The fourth and the fifth one are somewhat more substantive in nature. And this goes back to what kind of transaction structures are happening in Cayman Islands. And to me, I think from looking at it from an M&A perspective, the transaction structure that you've looked at in your comparison, both from a Delaware perspective and the Cayman Islands perspective, is a merger. So going private by virtue of a merger, and there I can completely understand, because under the MFW structure in the US, mergers are subjected to, until SB 21, subjected to a strict requirement of majority of minority and special committees. Whereas that, I think the thesis of your paper is that that is lacking in the Cayman Islands law, because when it comes to a merger, Cayman Islands does not require a majority of the minority. It does not require special committees, but companies are voluntarily including a special committee. But what is interesting is there are a couple of other transaction structures too in the Cayman Islands, such as a scheme of arrangement and the compulsory acquisition mechanisms, which include a majority of the minority requirement. Now, what is unclear from the paper is whether, because if those structures were used by companies going private, there would be limited difference between Delaware and Cayman Islands, because those transaction structures in Cayman Islands would incorporate a requirement of majority of the minority shareholder voting. So what is unclear from the paper, and which would be good to flesh out, is it that those transaction structures are not being used by Chinese companies which are listed in the US, which are incorporated in Cayman Islands? My intuition would be to suggest yes, because if you ask a company to use a method which is the easiest, that will the company will obviously use that. And if mergers are the ones which can be affected more easily without the majority of the minority requirement, it's natural for companies to do so. So I think looking and delving into a little bit more about the transaction structure, which is currently assumed to be the merger structure in the Cayman Islands, would be something to do, because that would change the nature of the outcome of the paper itself. So that's something to see whether there's some kind of a structural arbitrage in Cayman Islands. And the last thing is something that I venture into with some amount of trepidation, which is the methodology. So, for example, you've used the matched pair sample test, which to me seemed convincing as a method to use. It doesn't go into too many regressions and details, so I think it's a very easy. It's much more accessible to people who are not very empirically trained. But it's also the case that the match sample test could also incur some risks as well. So one question is whether there are outliers. So for instance, if you go back to this there are a couple of so there's one case which is an outlier. So if you look at the pair 3 here, it is an outlier in 2 ways, because on the one hand, the difference in pair 3 is quite high in terms of the premium, and the difference is quite high even in other areas such as the shareholding. So is that outlier going to change the mean or not? Seems to be a question, because you only have 4 samples, and one extreme sample could kind of change the mean. So I was wondering whether maybe you might have to explain a little bit more about how that impacts one way or the other. I don't think it changes the result, but there could be questions that a reviewer could ask, for example, as to whether there's an outlier which could change things at all. So maybe there is a need to relook at this or explain this a little bit. So these are the only kind of points that I had to think about from the paper's perspective, but otherwise it's a very interesting paper. It deals with 2 very critical issues. One is whether corporate governance matters. I think that's really goes to the heart of the discussion. And secondly, what are the acute issues that come in the context of going private transactions and squeeze outs, which is always a tricky and controversial issue in both M&A as well as corporate governance. Thanks.